Hey there everybody, let's talk about a common question that I get. What assets should you not put into a trust? Trusts are powerful estate planning tools, but they're not quite a one-size-fits-all solution for every asset. There are some things that you're better off leaving out, and if you've ever wondered why, stick around and we'll break it down. Today we're focusing on three main categories: vehicles, annuities, with a little bonus discussion on IRAs and 401ks, and life insurance policies. These are assets that often come up in trust planning, but can cause complications when mishandled. So without further ado, let's dive in. First up, vehicles. Now, technically you can put a car or any other vehicle into a trust, but in most cases, it's just not worth the hassle. Why not? Well, there are three main reasons as to why. First is the ease of transfer. Vehicles are incredibly simple to transfer upon someone's death. In many states, including California, all you need is the death certificate and a trip to the DMV. There's no probate involved, so putting the vehicle in a trust doesn't add much value. Frankly, your biggest hassle is just being present at the DMV in the first place. Second is lawsuits and asset exposure. Let's say that your car is in your trust and you get into a collision. The plaintiff's attorney is going to sue you, but they'll also name your trust as the defendant. This exposes the existence of your trust and makes it a potential target for creditors. While a revocable living trust does not provide creditor protection in California, why make it easier for someone to sniff out your other assets? And last is insurance complications. Many insurance companies don't love seeing vehicles owned by a trust. While it's possible to insure a trust-owned vehicle, it's an administrative headache you just simply don't need. Trust me, the fewer hurdles you set up for yourself, the better. Next on the list, annuities. These are often misunderstood when it comes to trusts, so let's clear up the confusion. So what's the problem? Ownership versus beneficiary designations. While a trust can technically own an annuity, there's often no need to do so. Annuities function much like retirement accounts. Naming a beneficiary directly allows them to bypass probate at your death. If you change the ownership to the trust after purchasing the annuity, you might trigger unnecessary fees or even a taxable event, as in the IRS views that money as having been distributed to you. So why create a headache when you can just simply name your trust as the beneficiary? However, let's detour into a couple bonus assets. Let's briefly talk about IRAs and 401ks. These are similar to annuities in that you shouldn't put them into a trust. Federal law treats these accounts differently, and retitling them in the name of the trust can result in penalties, immediate taxation, or just other headaches. Instead, name your spouse as the primary beneficiary and your trust as the contingent beneficiary. This ensures that your successor trustee can oversee and manage the funds while letting beneficiaries decide how to handle their own portions. But, and this is important, your trust must include the right language to allow the trustee to manage those funds effectively. However, that's a topic that's outside the scope of today's video. Last but not least, life insurance policies. This is a big one, and whether or not you should involve a trust depends upon your specific goals. Let's start with a simple approach. If your goal is to keep things easy for your beneficiaries, you can name them directly as the beneficiaries of the policy. This way, the funds bypass probate entirely, and your loved ones can use the money immediately. It goes directly to them. But here's the catch. If you want to control how those funds are used, for example, to ensure that they're invested wisely or used to support younger beneficiaries, you must name your trust as the beneficiary. This puts the money under the control of your successor trustee, who can manage it according to your estate plan. Just make sure that your trust includes the proper language for this kind of oversight. This is the trust approach, and it's the one that I highly recommend to all my clients. Having your trust be the centerpiece of your generational wealth strategy is the best way for the overwhelming majority of us to run our own estates. It's how mom and pops do it, it's how the rich and the super rich do it, and it's how you should do it too. On a related note, let's talk about a more advanced strategy, the Irrevocable Life Insurance Trust, or what we call an ILIT. An ILIT is a specific type of trust designed to own a life insurance policy. But why would you do this? Well, simple. It separates the life insurance proceeds from your estate, offering protection from creditors and avoiding estate taxes. So here's how it works. You transfer money to the ILIT to pay the life insurance premiums. The ILIT owns the policy, not you. And when the policy pays out, the proceeds go directly into that trust, bypassing your estate entirely. If you're building generational wealth or worried about estate taxes, this is a strategy worth considering. A word of caution though, you cannot simply create any old revocable living trust and put a life insurance policy into it. An ILIT is a very specific type of trust that is irrevocable, and if not set up and ran correctly, will result in you owing up to 40% of taxes on your own money. I've discussed irrevocable life insurance trusts in detail in a previous video, so I will link that here if you want to know all the juicy secrets. So there you have it, what not to put in a trust. Vehicles, annuities, and life insurance policies. Each have unique considerations, and in many cases, leaving them out of the trust may be the smarter move. That said, estate planning is not one size fits all. The best approach for you depends on your specific goals. So, as always, consult with a qualified estate planning attorney. But what do you think? Were any of these points surprising, or do you have any questions about other assets and how they fit into your trust? Let me know in the comments below, and don't forget to like, subscribe, and share the video with someone working on generating their own generational wealth. I'm attorney Andrew Bethell, and I'll see you at our next meeting.